Good morning, friends. Today's topic is whether the Domestic Violence Act and Section 125 of CRPC are in help of each other or they are having different area to decide their cases. The Bombay High Court, Honorable Bombay High Court, had recently held when no domestic violence is found in a domestic violence case, maintenance cannot be awarded to the wife on the ground that husband refused and neglected to maintain her. This is the finding of the Bombay High Court I am discussing in detail. Justice S.G. Meher of Aurangabad bench observed that concept of refusal and neglect to maintain wife given in section 125 CRPC does not exist in the Protection of Women from Domestic Violence Act 2005, that is in DV. The test is to prove the domestic violence and refusal and neglect to maintain are different. There were no provision in the Domestic Violence Act to test the refusal and neglect to maintain. The concept of domestic violence is specific as provided in DV Act. It cannot be compared with the concept of Section 125 of the CRPC Procedure Code. She never pleaded that the applicant husband refused and neglected her. It was not also the issue before the trial court. Considering the concept of refusal and neglect and granting the maintenance to wife in DV Act case is out of jurisdiction and extradition. The court held. The court quashed a session court order that awarded maintenance to wife in a domestic violence complaint, despite finding no domestic violence having been committed. The fact is, the wife had filed an application under Section 12 of the DV Act. The judicial magistrate first class considered the evidence and concluded that whatever she testified before the court was not pleaded in her application, and what she pleaded was not deposed before the court. In appeal, the additional session judge affirmed the JMFC's finding that there was no domestic violence and she was not entitled to monetary relief, house rent, refund of dowry, and compensation. However, however, the judge, considering the case as an application under Section 125 of the CRPC, held that applicant refused and neglected to maintain his wife and awarded maintenance. So the applicant approached the High Court in a revision application. Now, from the judicial magistrate judgment, the court appointed that he minutely scrutinized the wife's evidence and rejected her application. The court noted that DV Act is a law in addition to and not in derogation of any other law. Therefore, the wife may simultaneously claim relief under the DV Act as well as Section 125 of the CRPC. In this case, the complaint was under DV Act. What maintenance was awarded to her as per concept of refusal and neglect to maintain under Section 125 CRPC. Therefore, the court held that the additional session judge went beyond the pleading and law involved in the case. The court held that granting maintenance to wife in a domestic violence case based on the concept of refusal and neglect to maintain is beyond the jurisdiction of the additional session judge. Thus, the court quashed the judgment of the additional session judge and upheld the judicial magistrate's statement. This is the case Sunil versus and Sunil and other versus Jayashri and decided by the Bombay High Court. Thanks for watching.